So you're looking to cut through all the noise, right? Get the essentials on something complex without getting totally bogged down.
Yeah, get straight to the point.
That's what we aim for. And today, we're digging into something pretty weighty that's, well, been in the discussion lately, especially after those comments from Stephen Miller.
You mean the idea of suspending habeas corpus in the U.S.?
Exactly. Specifically around immigration cases.
It's definitely not a minor topic. It really goes to the core of our justice system. Even talking about suspending it, well, that means we need to look hard at the Constitution, at history.
For sure. And that's our mission today. We want to unpack this. We've got an article by Steve Vladek, some Wikipedia info on ex parte Merriman and habeas corpus generally.
Right. Also a Reason Magazine blog post, some Reddit discussions from our conservative and Rask conservatives.
And the Legal Information Institute's definition to keep us grounded.
So,
yeah,
a good range of sources.
Yeah. The goal is to bring it all together, give you a clear picture of habeas corpus, why suspension is such a big deal, the history, and, maybe uncover some surprising angles. Ready to jump in?
Let's do it. So, habeas corpus, what is it? Fundamentally.
Good starting point.
Okay, so the Latin, it literally means that you have the body.
Right.
And it's essentially a legal procedure, a type of court order, a writ that federal courts use. They use it to figure out if a state, or the federal government really, is detaining someone lawfully.
So it's like a check on the government holding people.
Exactly. It's a primary safeguard against, well, locking someone up without a good legal reason. The Legal Information Institute puts it simply. You bring the person before the court to see if their imprisonment is valid.
It feels like something with deep roots.
Oh, absolutely. This isn't new. The LII traces it back centuries, even connecting it to the spirit of Magna Carta in 1215, Clause 39. No free man imprisoned except by lawful judgment or the law of the land.
Wow, 1215.
Yeah, and English courts really developed it around the 1600s as a way to push back against unlawful imprisonment. It was a hard one, right?
So how did it become so central to the U.S. system?
The founders saw it as absolutely essential. James Madison, according to the LII, even argued for putting it right into the Bill of Rights.
Huh. Interesting.
And later, Chief Justice John Marshall, he described its great object as basically freeing people locked up without enough cause.
And the Supreme Court itself.
They've called it a fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Pretty powerful language.
It really is. So just to be crystal clear, this isn't about deciding if someone actually committed the crime they're accused of?
No, not at all. The LII is very clear on that. Habeas isn't about guilt or innocence.
Okay.
It's procedural. It asks, does the government have the legal authority to hold this person? Was the right jurisdiction used? Did they follow the rules?
Got it. So it's about the legality of the detention itself.
Precisely.
Okay, that makes sense. Now let's talk about suspending it. That sounds serious. There's this suspension clause people mention. What's that about?
Right, the suspension clause. It's in Article 1, Section 9, Clause 2 of the Constitution.
Article 1, Section 9. Okay.
And here's the crucial text. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it.
Shall not be suspended unless... That wording really jumps out. It sounds like suspension is meant to be incredibly rare.
That's exactly the point. Steve Vladek, in his analysis, really emphasizes this. The clause is there to limit when habeas can be suspended. It's designed to make sure judicial review of detentions is almost always available.
And Vladek also pointed out it was in the original Constitution, right, before the Bill of Rights.
Yeah, which tells you how fundamental the framers thought this protection was. It wasn't an afterthought.
Which brings us back to Stephen Miller suggesting suspension because of, well, immigration rulings the administration doesn't like. Vladek had some strong thoughts on that.
He really did. He called Miller's argument, and I quote, factual and legally nuts.
Wow.
His point is that using the suspension clause, just because you disagree with court decisions, that completely twists its purpose. It's meant for genuine existential threats, rebellion, or invasion, not as a way to sidestep the courts.
And Vladek highlighted the two requirements, didn't he? It has to be a rebellion or invasion, and the public safety may require it.
Exactly. Both have to be true. Just having an emergency situation isn't enough on its own.
He used that example of the student Rumeysa Öztürk, who was released from immigration detention.
Right. Vladek argued her release clearly posed no threat to public safety, so even if you argued there was some kind of invasion, the second condition wasn't met.
It's such a high bar. Why did the framers even allow for suspension at all? What kind of danger were they thinking of?
That's a great question. They understood that in truly catastrophic situations, like an actual armed uprising trying to overthrow the government or a foreign army landing on the shores, the immediate need to protect the public might, just might, have to temporarily override individual protections.
But they were wary of giving too much power.
Deeply wary. Which is why they put strict limits on when it could happen and also, importantly, who could authorize it.
Okay, so who does have that power? Can the president just decide?
No. The Legal Information Institute is very clear here. The power to suspend habeas corpus belongs to Congress. Only Congress.
Not the president.
Not acting alone. Congress can either pass a law doing it directly, or they could pass a law explicitly giving the president that authority temporarily. But the president doesn't have that power independently.
And the Reason magazine article mentioned Jonathan Adler agrees.
Yes, Adler concurs. Only Congress holds this power. It's about the separation of powers. They didn't want one branch holding that kind of authority.
That's a critical point. Okay, so we know what habeas is, the very strict rules for suspending it, and that Congress is in charge. Let's shift to history. Ex parte Merriman, 1861. What does that case tell us?
Right, Merriman. It's a really significant case from the very beginning of the Civil War. April 1861. Congress wasn't in session.
And President Lincoln was worried.
Deeply worried. About Maryland possibly seceding, about the rail lines to Washington being cut. So he acted unilaterally. He suspended habeas corpus in parts of Maryland.
And this led to arrests without charges.
Yes, quite significant ones. The Wikipedia page lists them. The mayor of Baltimore, the whole city council, the police commissioner, the police board, even a sitting U.S. congressman. All arrested and held at Fort McHenry, no charges filed.
That's pretty shocking. And wasn't there a newspaper editor involved? Francis Scott Key's grandson?
Frankie Howard, yes. He edited a Baltimore paper and wrote editorials strongly criticizing Lincoln for suspending habeas and, well, ignoring the Constitution.
Then they arrested him too.
They did. On orders from the Secretary of State, Seward. Troops arrested Howard, took him to Fort McHenry, the very fort his grandfather wrote the anthem about, and held him without charge or trial. He later wrote a book about it.
Wow. So the Chief Justice at the time, Roger Taney, he got involved.
He did, acting as the circuit judge. He issued the ruling in Ex parte Merriman. And his conclusion was blunt.
What did he say?
He ruled that only Congress had the constitutional power to suspend habeas corpus. The president couldn't do it alone. He ordered John Merriman released.
But Lincoln, he didn't follow the order.
Essentially, no. His argument, as historians understand it, was that it was an emergency. Congress was out. The nation was facing rebellion on a massive scale, and he needed to act now to preserve the Union for public safety.
Michael Burlingame, the historian, thought Lincoln had a point.
Burlingame felt Lincoln had a good argument, yeah. Given how long Congress could be out of session back then, things could happen fast.
Still, ignoring a Chief Justice's order, that sets a precedent, doesn't it? Even in a crisis.
And that's the heart of the debate that continues even today. Taney's legal point was clear, but many scholars argue Lincoln's actions were, perhaps, understandable, maybe even necessary, given the extreme circumstances. The survival of the country was at stake.
It's that classic tension.
Absolutely. And we should note, Congress did later pass laws related to suspension during the war, and even the Confederacy dealt with similar issues. It shows how tough these choices are in wartime.
Okay, fast forward back to today. We have Stephen Miller talking about suspension again, but this time for immigration, calling the border situation an invasion. How are people reacting now?
Well, as we said, the Reason article immediately points out Adler says only Congress can suspend it. But to get a feel for the public conversation, we looked at those Reddit threads, our conservative and rask conservatives.
Yeah, what kind of things came up?
A real mix of opinions, actually. One user, Celebral63, made a good point about due process, that it means following the established legal process, which isn't always a full court hearing.
That relates to the arguments about people missing immigration hearings.
Yeah, users like Original Lord Turtle and Schurzeg mention that, suggesting maybe rights are forfeited. And others, Indefinite Retrieval and Schurzeg, again, worried about the system just being totally overloaded by the number of cases.
But the big one, is it really an invasion in the constitutional sense?
Huge point of debate there. Some users, like Solid Welder 151 and Toe60, seem to lean into that framing, using the invasion language.
But not everyone agreed.
Definitely not. Others, like Seraph Lance and Wonderful Driver 4761, pushed back, calling it hyperbole. And user Harshaw J asked a really sharp question, essentially. How can it be an invasion if a previous administration seemed to allow it? Kind of like being invited in.
So even within those groups, there's disagreement on that core term.
Yeah, it suggests, real tension within conservative thought maybe on balancing security and liberty, especially with immigration.
What about other constitutional worries? Did those come up on Reddit?
Oh, yes. A lot of users expressed serious concern about suspending a right like habeas. One person compared the feeling to being in an abusive relationship, like being pushed too far.
Strong analogy.
And others, Isaac Bound, for instance, were very direct, warning it's a step towards a police state.
What about the courts?
User Block Affection at 413 worried that if you suspend habeas, what stops the executive from just ignoring the courts altogether? And Milkbug raised the practical fear of ending up detaining people who actually have a legal right to be here.
That's a critical point.
And interestingly, Mediocretes 08 suggested that just talking about suspending habeas corpus publicly is maybe a bad sign for a healthy political climate. And Vlandis 19 argued habeas actually protects everyone's safety, even undocumented people, by ensuring process and preventing illegal stuff like renditions.
It's quite a spectrum of concerns, even from those expected maybe to favor tougher enforcement. Now, thinking more broadly, habeas corpus hasn't just been static since the Civil War, right? There have been more recent developments.
Absolutely.
Yeah.
21st century has seen major habeas cases, especially related to detentions after 9/11.
Like Guantanamo.
Exactly. The big one was Boumediene v. Bush in 2008. The Supreme Court said the detainees at Guantanamo Bay, even though held outside the U.S. technically, do have the right to habeas review in federal court. That was huge.
But haven't some recent cases maybe narrowed habeas a bit?
Yes, in other contexts. Cases like Brown v. Davenport and Jones v. Hendricks have made it somewhat harder for state prisoners to get habeas relief in federal court. So it shows the law is constantly evolving, and the courts keep interpreting this right in new situations.
Okay, so pulling it all together, these sources really highlight this core conflict. On one side, you have the push for immigration control, the argument that there's an emergency, maybe even an invasion, requiring extreme measures.
And on the other side, you have this fundamental right, habeas corpus, protecting against unlawful detention. And the Constitution setting very specific, very high bars for suspending it, rebellion or invasion, public safety requires it, and only Congress can do it.
Right. And that Ex parte Merriman case just looms large as this historical warning about executive power versus individual rights in a crisis.
It really does. It underscores why judicial review is so vital.
So let's summarize the main points for everyone listening. First, habeas corpus is this bedrock legal protection against being locked up without lawful reason. Deep historical roots, right in the Constitution.
Check. Second, suspending it. Extremely limited. Only for actual rebellion or invasion, and only when public safety truly demands it.
And third, the power to suspend belongs to Congress, not the president acting alone. That's crucial.
Definitely. Fourth, Ex parte Merriman shows the historical tension and the stakes involved when executive action clashes with the judiciary over this right.
And finally, the current debate over immigration and the invasion language forces us to ask if today's situation meets that incredibly high constitutional threshold and what suspending habeas would really mean for rights and the balance of power.
That sums it up well. And I think the real significance here is understanding the delicate balance habeas represents. It's this potential emergency power may be needed in the absolute worst case scenario.
But incredibly dangerous if misused.
Exactly.
Yeah.
It carries this huge risk to fundamental liberties. So understanding the history, the constitutional rules, the current arguments, it's all essential for grappling with this.
So for you listening, as you've taken this deep dive with us, here's something to chew on. Considering the history, the Constitution, the debates we've talked about, what do you think are the real legitimate limits on suspending habeas corpus in a democracy today? Where is that line? It's a tough question, right at the intersection of security and freedom. Thanks for joining us for this deep dive.